Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will discuss about the Labor Standard Act, Chapter 3, Accident Compensation, and especially Article 78, the compensation for medical treatment. So, could you explain the terminology, please?
Yes. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. Accident compensation. So when employee had a work-related accident or work-related disease, then employee should compensate the medical treatment. Also pay back pay like a shutdown allowance during the suspended period. So this is a kind of mandatory duty provided by the employer. But we have an industrial accident compensation insurance. When employee should join this insurance package, and then they are exempt from application of this work accident compensation. So this accident compensation is stipulated by the Labor Standard Act. So usually the industrial accident compensation insurance, it covers those who should take care of their medical treatment more than 4 days, 4 days or more. But less than 3 days, this industrial accident compensation insurance will not cover. So such a short period of time, it must covered by the employer. So it is a big difference. So during the medical treatment, employees are entitled to all kind of doctor's checkup, also the operation or medication or the hospitalization or nursing services. They are all included in nursing, like medical treatment. Also during that treatment, the patient or employee receive 70% of their the average wage that they used to receive. So this is really very important. But in order to be eligible or entitled to this protection, then this accident must be related with the work-related accident or work-related disease. So if I think it is simple to treat it as a work-related accident when they have a work-related injury, that's no problem. But disease or some kind of mental illness like the depression or some the stress related some disease like stroke or the heart failure. So those are related with some stress or fatigue. So in that case, in order to be applicable for protection or the compensation by this industrial accident compensation insurance, they need to have some proof, or the employee should verify this accident is closely related with the work. Yeah, so I think it's very hard to prove such a verification. So in that case, labor attorney can support those patients with special knowledge, because we have been working in this field as our job. So how we prove is we have to review their medical record, also work environment, also their personal statement, how they were affected by their the working environment. So through considering those facts, we prove that this disease or illness were closely related with the work, then they can be accepted as a work-related accident or disease. Yeah.
So if it's under the blue-collar working environment, and you are treating like machine, you can find out that this accident happened during the working environment. But in case of white collar workers, illness such as like mental illness or depression, something like that, it will be very difficult to prove it's work related accident. So that's rather than the individual employee to deal with this, it's very important to consult with the labor law firm like Gangnam Labor Law Firm. So is that the point you want to make?
Yeah, thank you for explaining. And yeah, that's true. So usually work-related injury is no problem to be treated as a work-related accident. So nobody pay. So it is very clear they have some compensation from the employer or the government, but stress-related some disease like stroke or heart attack, or even the ear ear disability, like they cannot hear. So such a disease, they have been influenced by working environment, or they have some personal the medical history. So in that case, how we prove is we should support what has caused such a disease so seriously in this time. So we review that there is more than 50% close relationship between work and disease. Then that is how we work hard to find the evidence or related some kind of evidences. So this is how we prove. So far, I have successfully represented. So I can distinguish whether this case is acceptable as a work-related accident or not. So this is kind of special law I have obtained through my experiences.
Yeah, I think it's very important to make a right point to address this work-related accident, so that the employer can benefit from the compensation. So, do you remember any case?
So, like especially this is application or accident compensation. So usually when they have injury while they are working, so that's no problem. But they have some depression or some kind of a special cancer or some stroke or some heart attack. So such a cases is very difficult to prove. But so don't give up their legal rights. Just contact us and explain. Then we'll check and we'll support. Because when they are dead due to such a stroke or some heart attack, then how a surviving family? It's very hard to live decently without enough income in Korea. So how we can support these survivors? Then when you have the survivors pension, so in order to get the survivor pension, we have to prove the victim employee was dead due to the some work-related working environment or some such related factors. So please don't give up and just check with this labor attorney. We come and consult with this labor attorney. Then we'll provide the best option. Just give up, or there are some certain percentage you can pursue and achieve this one. So far I made many patients or their survivors happy through my successful cases. I'm still very proud of those successful jobs.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.